Very good evening to everybody. Webtel, as you are all aware, is a software company which is in various compliances. We are pioneers of TDS and XBRL softwares in the country, and also various other solutions. And we have a team of professionals led by CAs, CS, and various legal and software professionals. Next slide. We have also partnered with the government for various initiatives, and we have a bouquet of products like Virtual Office, which are websites for CA firms, which a new offering, which is a mini ERP for CA firms. Also, various TDS, income tax softwares, or a combination thereof, which is Goldmine, and WebSign, which is for digital signing of documents, etc. So we have a bouquet of products, and our latest addition to that is a work at home solution, which we proudly call as WA. And in this pandemic situation, I think we all have faced problems in working properly, and because offices are not fully functional. And let us see this. Social distancing is a new norm in the unprecedented situation. Stay home, stay safe. While safety is a big concern, how long can we wait for the situation to become normal? How to keep working while taking necessary precautions is a challenge for everybody. We need a utility to let us work at home. What is WA or work at home? WA is Webtel's new utility which allows access from anywhere to Webtel, Talibusy, etc. other servers to virtual server in data center in India, available 24/7, and it also has an option to static IP in on-premise server. Now the question would be how WA works. Let us see. Get server access through WA. Softwares like Tally, Busy, Webtel, etc. installed on the server only. Only WA installed on employee PC, no need for other softwares. Employees can get anytime, anywhere access to softwares on server, and access to user as per need to use basis. WA work at home solution for everybody to help you work. And this is how you will work. There will be a central server either on your premises or on the cloud, and each one of you can access the system server through your own homes, and it will be as if you are working on a LAN environment. Such good speed with necessary hardware solutions and the Webtel solution. A small step by Webtel for safety and security of your clients and the staff. Now this QR code is there, which you can scan on your mobile phones if you want to know more about WA utility. And already many of our CA friends and advocate friends, other professionals have already started working from home, and on a very limited basis they go to offices and they are able to work at home using WA utility. So you can use your mobile phones scanners to scan this QR code and know more about this WA utility.
Without wasting any time, let us introduce the second speaker for today, Mr. Sudipta Bhattacharjee. Mr. Bhattacharjee is a partner at Advaita Legal, a reputed law firm based out of Delhi, and he has more than 12 years of experience in providing strategic tax and allied commercial and legal advisory services to its clients, which are in various diverse sectors, and in structuring, drafting, reviewing, and negotiations of various contracts. He is a lawyer by qualification and has graduated from the prestigious National University of Judicial Sciences, Calcutta. Mr. Bhattacharjee specializes in all pre-GST Indian indirect tax laws, including customs, excise, service tax, as well as GST and contract documentation related services. He has been involved in providing strategic advice on GST transition and implementation in India to businesses across sector and has undertaken several training sessions, has taken several training sessions educating clients and general public about the impact of GST on their key business processes. Mr. Bhattacharjee has written extensively on GST and other tax issues in newspapers like Business Standards, Economic Times, and tax portals like VAT Infoline, Tax Sutra. Mr. Bhattacharjee has been recognized by the International Tax Review, that is ITR, as one of the top indirect tax leaders for 2017 and 18 for India. It is our privilege to have him as a speaker on this webinar. Now over to you, Mr. Bhattacharjee, for taking this session forward.
Thank you. Thank you for the kind words. Am I audible?
Absolutely, sir. Yes, you're very much audible.
Great. If my slides could be shared, I'm having trouble sharing the slides here. Yeah, thank you.
Yeah, it is there, sir. It is
yes,
there.
sir. It's on.
Okay. Let's go to the third slide, please. So, ladies and gentlemen, thank you for logging in. We are going to discuss in the next 25 minutes two topics. One is promissory estoppel, and second would be transit e-way bill related jurisprudence. So talking about promissory estoppel, the starting point has to be Article 39C of the Constitution, which talks about state's duty to ensure that there is no concentration of wealth. So basically, and from this flows the various schemes and incentives which try to incentivize industrialization in slightly backward areas also. It is in this context that when in 2003, Uttarakhand and Himachal Pradesh, a new industrial policy was introduced, which amongst other things thought about envisaged 100% central excise exemption. And pursuant to that, notifications were issued. Many companies have been taking the benefit of that. And it is in that context that we will examine the issue of promissory estoppel. Now, what is doctrine of promissory estoppel? There have been many landmark cases, Motilal Padampat, Indo-Afghan trading in 70s and 80s. We'll talk about, and we have accepted our judgment from 1995 of the Supreme Court, which basically says that if a party has made a promise and another party has acted on it, has altered his position, then the promisor cannot go back on that promise, except where the equity in the public interest so demands. Except where the equity in the public interest so demands. I repeat with emphasis, because this is where the entire set of litigation on promissory estoppel emanates from. That whenever a government, state or central walks back on a particular promise, the analysis has to be whether public interest and equity does it so demand. Next slide, please. So we spoke about the 2003 policy that effectively got rescinded after GST came in, because the rescinding of that notification led to a lot of heartburn among industry, a lot of losses, GST Council suggested, and sometime in October 2017, a budgetary scheme was announced by the central government. One of the key features, next slide please, one of the key features of the budgetary support scheme is the fact that the benefit was restricted to 58% of CGST and 29% of IGST that was paid in cash. Shubham, move to the next slide, please. So instead of a full excise exemption, the benefit was restricted to, as I said, 58% of CGST, 29% of IGST. Clearly, it's a fairly large, significant scale down for anyone who was availing a complete central excise exemption, and accordingly, many players challenged it. One of them reached the Delhi High Court, which is Hero MotoCorp, and we'll discuss the case of Hero MotoCorp, what happened in there. Next slide, please. So in the case of Hero MotoCorp, the rescission of notification 50 by 2003, which prescribed for exemption to eligible units in Uttarakhand, central excise exemption, that was rescinded, as I said, with effect from July 1, 2017, and that was challenged by Hero on the grounds of violation of promissory estoppel. Unfortunately, the government, the Delhi High Court overruled rebutted that particular argument of doctrine of promissory estoppel. They did not accept, and the various key points that they laid down are as under. Firstly, they laid a lot of emphasis on the fact that GST, in the post GST, the whole indirect tax regime has changed, it has been overhauled, so very minimal exemptions are now considered. They also placed a lot of emphasis on section 174(2)(c) of the CGST Act. 174(2)(c) is part of the repeal and saving provisions of the GST law. So which basically says, the C starts with saying that the repeal shall not affect any right, privilege, obligation, etc. Creates an exception provided that any tax exemption granted as an incentive against investment shall not continue as a privilege. So a specific exception has been carved out for discontinuance of a investment-linked incentive. And this was something that was heavily relied upon, emphasized upon by the Delhi High Court to rebut or overrule the argument of promissory estoppel. Next slide, please. Other points, and basis 174(2)(c), it was held that the rescinding notification number 21 was in accordance with that statutory framework under 174(2)(c). And it was also highlighted that the industrial policy has undergone a lot of change. It was highlighted that GST is, effectively a merger of various pre-GST taxes, and hence inter se credit between various taxes that used to be an issue earlier, that is no longer an issue, because under GST there is somewhat a seamless flow of credit across various levels. And it was highlighted that the promises in return for investing in Uttarakhand was a privilege and not in the nature of right. We'll come back to this point. This is a very, very critical point on which the case turned. Basis all of this, relying upon and emphasizing the fact that the constitutional validity of 174(2)(c) has not been challenged, the Delhi High Court concluded that there is no case of invocation of doctrine of promissory estoppel. So key takeaway from this judgment is, if any of us are suffering or want to invoke promissory estoppel, we have to, in order to distinguish, in order to get Hero MotoCorp judgment out of our way, we have to challenge the virus of section 174(2)(c) if we wish to, if we want to have any chance of success. Now, let's go to the next slide, and we will deal in greater detail on the point of right versus privilege. If you see, 174(2)(c) is excerpted in entirety. And as we saw in the first slide, this uses words like right, privilege, obligation, or liability. And then comes the proviso, which, although only talks about privilege. So it's a settled rule of statutory interpretation that when different words are used, different meanings are intended. So if right, privilege, liability, obligation, separate words are used, they all have separate meanings in law. But the proviso is only being carved out for privilege. It is saying that a tax exemption, which is investment linked incentive, is a privilege, and basically will not qualify as a privilege for the purposes of the foregoing section. Proviso, as we know, is an exception to the main rule. So when the main rule talks about right, privilege, obligation, liability, exception is only carved out for privilege, not for the others. So this is an important statutory point to remember. However, Delhi High Court did not get into these niceties. Delhi High Court straight away said that the exemptions granted were in the nature of privilege, and hence, as per 174(2)(c), there is no case for promissory estoppel. It is my humble opinion, with the greatest of respect to the Honorable Delhi High Court, that this probably was a conclusion in error. Let's move to the next slide. The reason I say this is a conclusion in error is the distinction between right and privilege is well recognized. When a taxpayer fulfills the conditions for claiming an exemption, then that exemption becomes a right. It is no longer a privilege. Availability of an exemption upon fulfillment of some conditions, that is a privilege, that is a concession. Once I have fulfilled the condition, I have acted based on that promise of a concession, it becomes a vested right. And this is not my interpretation. This is an interpretation that has also been blessed by the Supreme Court in the case of Kanak Exports earlier. So the Delhi High Court, to the extent that it failed to make a distinction between right and privilege, I think it is humbly submitted, is in error. Second point is, section 174(2)(c) is not a prohibition on exemptions. It is, as we saw, a very simple thing. It says that this particular thing will not constitute a privilege. It does not talk about being a right. It does not talk about being an obligation. Only for privilege, exception has been cast. So 174 2C cannot be read as a prohibition on grant of exemptions. CGST Act in section 11 clearly empowers the government to notify exempt supplies. So to that end, where Delhi High Court emphasized on the fact that the design of GST is antithetical to exemptions, I think that sort of a blanket statement was probably erroneous. So anyone who is planning to challenge the Delhi High Court judgment in appeal, or wants to launch their own challenge on a similar facts, will have to try to distinguish and bring out these points when they mount their own challenge. However, if the attitude of the Supreme Court is anything to go by, I don't think there is much cause for optimism, because Supreme Court recently took a very narrow view vis-a-vis promissory estoppel in the case of VVF Limited, and we will deal with that. Let's go to the next slide. So VVF was not in the context of GST, but nonetheless definitely worth discussing. This was in the context of, so there are 2 or 3 sets of appeals. It was a batch matter. The first batch, which became the leading batch of matters, pertained to central excise exemption that was granted in 2001 after the massive earthquake that rocked Gujarat. So for certain areas like Kutch, etc., which were backward, incentive was granted by way of an excise duty exemption. And it was a complete exemption. However, sometime in 2008, the exemption was amended, and instead of 100%, it was made to be a 34% exemption. So a massive scale down. And it was this notification, amending notification, that got challenged in Gujarat High Court by various parties, and the SSEs won before Gujarat High Court on the ground of promissory estoppel. The High Court accepted the conditions, and of course then the government went on appeal, the revenue went on appeal, and it is that appeal of the revenue which has succeeded before Supreme Court last month. So the Supreme Court basically said that notification 16 was in the nature of a clarification, which is frankly quite surprising. They said that it was to clarify the basic intent of the main notification. The objective of the main notification was to grant exemption only on the activity of value addition and not something else. And and accordingly, the doctrine of promissory estoppel cannot be invoked. The court also spent a lot of time discussing what is public interest and how public interest is a recognized exception to promissory estoppel. Let's go to the next slide. So as I said, they spent a lot of time and effort on discussing what is public interest. And here, undue emphasis, in my humble opinion, undue emphasis was placed on the fact that there have been a lot of fraudulent activities vis-a-vis these exemptions. The government kept arguing that since there have been widespread fraud, people have been misusing this benefit, people have been taking this benefit without conducting actual manufacture, so on and so forth. They were forced to introduce this condition 16 to reduce the exemption from 100% effectively to 34%. And unfortunately, Supreme Court accepted this argument. They said that if fraud vitiates all, and if the idea is to stop fraud, then it is in supervening public interest. The Supreme Court also went on to say that notification 16 is not taking away any vested right. It is clarificatory in nature, like we discussed. And the objective was always to grant benefit to genuine players and not to fraudulent, fraudulent players. So that point is well taken. We can go to the next slide. So that point is well taken. It is well recognized in law that fraud vitiates everything. But to my mind, with the greatest respect, I must submit that Supreme Court probably was probably this was a disproportionate sort of a example, disproportionate sort of a conclusion. I mean, imagine this, probably a far-fetched analogy, but there is a lot of discussion about GST frauds, ITC input tax credit frauds under GST. If tomorrow government decides that we will only give 34% credit, I mean, that would be disproportionate, right? There are a lot of ways and means in the law to prevent abuse. So just because there is abuse, you cannot take away the benefit, curtail the benefit by 66%. To my mind, that is disproportionate. And to that extent, and to the extent that VVF case decided or depended heavily on the fact of on the fact that there was widespread fraud, it can be factually distinguished. So yes, I mean, as a conclusion, yes, VVF case definitely dilutes the strength of our argument based on promissory estoppel. Anything that we may, take in future, but all hope is not lost. This is not the last word on promissory estoppel. Factually, both VVF and Hero MotoCorp, as we saw, can be distinguished, and so any of us who are planning to mount any challenge on the basis of promissory estoppel ought to keep these two cases in mind. In the next slide, let's go to the next slide. In this slide, we will talk about one live case that might open up and lead to further litigation in terms of promissory estoppel. Some of you may be aware that Uttar Pradesh came up with an industrial investment policy in 2017, which granted SGST refund of SGST paid in cash to a certain extent, subject to certain proportions. Now, recently, state government has issued they are calling it a standard operating procedure. It came out on June 12th, which basically says that to the SGST reimbursement would be reduced to the extent of SGST IT credit that is available in the credit ledger. It also imposed certain other restrictions on interstate sale. So the question that arises is, how can something which is called a SOP go beyond the policy in terms of imposing a restriction that is beyond the rigor of the policy? And also, how can the benefit of that is granted in 2017 be taken away even without amending the policy to something like a SOP? So I think this will probably be reaching the Allahabad High Court in the next few months. So this will be a space to look out for, to see how the jurisprudence on promissory estoppel further shapes up. The next topic that we are going to touch upon is are the various disputes that have emerged in the context of e-way bill, or basically goods in transit. So the legal provisions that pertain to this issue are section 122, which makes it an offense for a person transporting goods without valid documents. Section 130, which provides for powers of confiscation for a person who supplies or receives goods in contravention with an intent to evade. And section 129 is detention of goods in transit if there is a violation of provision of the act. Now, all of these are fairly wide-ranging powers, and there has been a lot of allegations of misuse. One of the all of us remember in 2017, one of the pillars of GST was free transport or free movement of goods. The state checkposts were to be abolished, and they have been abolished. But effectively speaking, the roving squads still create quite a menace. They still put a barrier to interstate free movement of goods. Recognizing this, a circular was issued in 2018 saying that minor discrepancies in things like in e-way bill, for that goods should not be detained. Minor discrepancies, the examples that were given were errors in address, error in 4 or 6 digit HSN, error in 1 or 2 digits of the vehicle number, spelling mistakes. These points were outlined. However, this has not helped much, and we can go to the next slide. This has not helped much, and we have had various cases, literally dozens of cases from high courts, from appellate authority and the GST on the issue of detention, on the issue of frivolous detention rather, and parties have had to knock the doors of the courts very often, unfortunately. Key learnings that emerge from some of these decisions I've tried to summarize without getting into each of the decisions. The first point is, in case there is a classification issue involved, and detention then has to be very limited for a very limited period, the state in which the detention happens cannot basically take action. They can only prepare papers and send a communication to the original assessing jurisdiction saying that we believe there is an issue in classification, please look into that. That is all, and that is the extent of detention that that anyone can do. So if goods are being sent from West Bengal to Delhi, and the officer in Delhi stops the vehicle for detention under 129, and on the issue of classification, this is the limited power. He can detain it only for that 1 hour, 1.5 hours that it is required to make a documentation and send communication to the West Bengal authority saying that I believe there is some error in the classification, please look into that. Similar for valuation disputes also, detention cannot happen for valuation except for communicating to the assessing jurisdiction. Similarly, for if a driver of the vehicle has opted for a different route than usual, that cannot be a ground for detention. If a driver has taken a wrong turn, traveled beyond the destination by mistake, that cannot be a ground for detention. If there is even a typographical error, and this is a fairly extreme example, where instead of 2000 kilometers, the e-way bill said 20 kilometers. It was clearly a typographical error. And even in that case, it was held that detention was invalid. And I touched upon section 130. So let's talk about, in the next slide, we will talk about Synergy Ferticum case of the Gujarat High Court. Let's go to the next slide. Synergy Ferticum, this is a landmark decision that has come vis-a-vis interpretation of section 129 and 130. They have laid down some 16 points which have been followed by several other high courts, as well as, of course, several other cases in the Gujarat High Court itself. The key points vis-a-vis 129 and 130 that they lay down are that 129 and 130 operate in different spheres. For invoking, so just because there is 129 invoked, you cannot automatically invoke confiscation powers under 130. The threshold for invoking confiscation powers under 130 is much higher. The authorities have to be prima facie satisfied that there is an intent to evade tax. Without satisfaction of intention to evade tax, section 130 cannot be invoked. And they have also clarified that sections 73 and 74 under GST, which deal with demand, recovery, show cause notice, etc., warranted for the purposes of interpreting 129, 130. So all these judgments that we saw, including Synergy Ferticum, clearly, while they are laudable, they have given relief to the SSEs, they have not given the desired level of protection. They have not given the sufficient level of ease of business, ease of transit for SSEs. So as an alternative and a more aggressive strategy, if any of us, any of our clients are facing issues in a particular location, in a particular jurisdiction, it may be a good idea to explore filing a writ challenging the very validity, constitutional validity of section 129. There are strong grounds for that, and 3 writs have already been pending, already been filed just before lockdown on this issue in Kerala, in Gujarat, in Bombay. And this can be a strategy worth looking at. Some of the key arguments are, of course, the fact that extraordinary powers have been given to the officers without much of a checks and balances. There is no distinction between major and minor violation in section 120. All have been unequals have been treated equally, which is a violation of Article 14. It effectively tantamounts to levy of GST on a transaction, though indirectly, even though something is not even a supply. And so to that extent, it is going beyond the constitutional power to levy GST, constitutional power under 246A. And of course, this is clearly a restriction on free movement of goods. So all of these grounds, to my mind, are strong grounds. So any of us, our clients, are suffering because of persistent issues in transit of goods, this is worth exploring. With that, I thank you.